All rise. The Supreme Court of Law is now in session. Honorable Chief Justice Robert J. Thorson presiding.
Good morning, councils. You may be seated. Yes. Will the court please call the case?
This is Supreme Court case number CRA23-013. People of Guam Plaintiff Appellee versus Sean Gumatauta Manglona, Defendant Appellant. Appearing for the Defendant Appellant is Attorney Peter C. Paris. Appearing for the Plaintiff Appellee is Attorney Nathan Tennyson. The panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Attorney Paris reserves 5 minutes.
Mr. Paris, Mr. Tennyson, you may proceed, Mr. Paris.
Good morning, Chief Justice Torres, and may it please the court. In this case, Mr. Manglona's conviction must be vacated because the statute on which he was convicted for advanced stalking was unconstitutionally vague. And second, even if the statute passes constitutional muster under the void for vagueness doctrine, there was still insufficient evidence under the plain error standard to convict him of the element for
Can you speak a little louder, Peter, Mr. Paris?
So with respect to the first issue, as to constitutional, whether or not the advanced stalking statute was void for being unconstitutionally vague, there are 3 elements which the government, which were impermissibly vague. And those are the elements of maliciously, repeatedly, and in violation of a court order. Now, this court has addressed the standards for the void for vagueness doctrine in a number of cases, including People versus Tafong and in Shimizu. And the court has already articulated a test to apply regarding this issue. And under a void for vagueness analysis, we must first look at whether or not the statute affords fair notice of what is prohibited. And in this case, if we look at the element of maliciously, we look at the facts. We have Mr. Manglona showing up at his former spouse's house 4 times. The first time was on or around the day that a stay-away order had been issued in another case. It was shown that he was knocking on the windows of his former spouse's house, calling out, "Babe." There were no interactions between he and the subject of the stay-away order. 60 days later, there was another contact. This time it was on December 19th at 6 p.m. He was found sitting down in front of his house while the alleged victim was parking her car, and there was an interaction at that time.
So Mr. Paris, you alleged in your arguments that in reference to the definition of maliciously as provided in the advanced stalking statute, you seem to suggest that there has to be some ill will, some evil motive in order for the malicious element to be satisfied. Is that the only way in which a person can act maliciously under the advanced stalking statute?
I honestly don't know, and that's the problem. And while, there's no statutory definition under the advanced stalking statute, that's number 1. Number 2, no jury instruction was given regarding what maliciously means. Number 3, the court on the record stated that there was no definition and that there was an expectation that there was vagueness regarding the definition and that the jury would probably have questions. So,
but the court did provide an instruction. It instructed the jury that on on the definition of advanced stalking. And the court further instructed on the essential elements of advanced stalking, and that's that the jury had to find that Mr. Manglona acted, as you stated, maliciously, repeatedly, and in violation of the court order. And then it's my understanding that because you're asserting that there are no definitions for these terms, that then the trial judge then relied on common sense understanding of what these statutes provided. But in terms of the malicious intent, again, is the only way to violate. I understand you're saying that there's no definition, but does that is solely restricted to an ill motive, that a person has to have some evil motive as opposed to just violating the elements of the offense, and that is that he acted contrary to those provisions in the statute.
That's the very issue. Your Honor asks me, what is maliciously? Can you violate? Can that be interpreted in different ways? Yes. Can you argue that it would be violated in different ways? Yes.
So what are the
Which
different
way?
ways, I guess, as I'm asking?
Intent to harm, intent to injure, ill will, wickedness,
What
intent to
about
violate a court order.
what about just disregarding a court order?
Well, that would be a separate element, I would argue.
Yeah, but wouldn't that be one way of committing the offense maliciously? If there is an outstanding court order that applies to you, that you stay away from the victim, and yet through your actions, you just completely disregard that court order.
I don't know. I don't know. That's the problem. Is that sufficient? Because maliciously is not defined in statute. And if you go to a dictionary, you'll find 5 different definitions. If you go to another dictionary, you'll find 5 more. If you ask 5 different police officers, what does maliciously mean to you? You'll probably get 5 answers. If you ask a layperson who's sitting on a jury, I doubt all of the jurors could even give you a definition of what malicious or maliciously even means. Does it have to be actual malicious malice? Can it be implied malice? That's the problem. And we don't know. So without a statutory definition, without a prior case holding, you know, the people cited to some cases. They cited to the McGill case, which I think was South Dakota. They cited to the Gaylord case, which is Florida, in addressing whether or not malice was vague or not vague. And in those courts, it was found no, it wasn't, because in the Florida case, there was a prior holding.
No, you just triggered a thought in my mind in reference to you're saying in terms of the ambiguity. So if there was a outstanding court order that applied to Mr. Manglona to stay away from the victim, and the actions are that he came upon on the premises, the various interactions that you had started to itemize, then him just disregarding, again, going back in my mind, just disregarding the court order, then, and the court did the court define the word recklessly? I mean, he went in there with the intent to proceed to that he willfully, maliciously, and repeatedly proceeded to harass the victim in this case. And so if he willfully undertook these actions, then could it be then argued that his actions were in, again, reckless disregard of the law?
I think that the term maliciously modifies the word harasses. I believe that's what it goes to, not to the violation of the court order, which would be a separate element as to the harassment in a violation of a court order.
Right, I understand, but we're trying to focus in on, as you've pointed out, what does the term malicious mean? And the court did provide a jury instruction, or did it, in reference to acting in reckless disregard of the law.
In this, under our statute, I believe the requirement would have been willfulness. But again, whether it's willful, malicious, repeated, or in violation of court order, those all go to the object, which is the harassment. Why did you harass? Did you harass her willfully? Was it malicious? Well, what does malicious mean? Does it wouldn't be the violation of the court order, because that's a separate element.
Well, okay, breaking it down, which is helpful in terms of how you're presenting it. So the willful conduct can it be said that by Manglona intentionally violating the court order by showing up at the victim's house, that number one, he acted willfully. And number two, his disregard for the court order and the legal rights of Manami in terms of not being harassed, despite the stay away order, doesn't that demonstrate a malicious behavior?
That would be for Your Honor to decide.
Right, yeah, but you can help me to try and decide that by
I can't because it's so vague. I don't know. Was there a required showing that the violence?
I don't think we have an issue with repeatedly and the court order being in existence. Is that correct?
Well,
your argument focuses on just the malicious definition.
As to sufficiency, but as to vagueness, it's all three.
Well, I mean, he repeatedly visited Manami at her home on multiple occasions. Doesn't that satisfy the repeated element of the offense?
Again, I don't know. We don't have a prior court ruling which defines.
I mean, the argument here is common sense in part also. I understand that it would be we wouldn't be here today if we had all these definitions, but in my mind, that doesn't necessarily mean that it's the end of the case.
Well, we have 4 allegations of repeated. We have one that occurred 60 days prior. So is 60 days and the next interaction, does that constitute repeated? What if it's 1 year? What if it's 5 years? What if it's 10?
Yeah, but let's focus on the facts of this case, because that's what the jury had to determine whether it was repeated. His actions satisfied the repeated part of the definition of the simple stalking statute.
I don't think it's a jury issue. I think the repeated issue is a legal issue, and whether or not it passes constitutional muster under the.
So you can't say that people of ordinary intelligence exercising their common sense knows that if a person comes there, defendant comes to the home that he's not supposed to be several times over a period of time, that a reasonable person can conclude that he had repeatedly come about the premises?
One might, another might not.
Why might the other not come to that conclusion?
They might think repeated must mean consecutive days of a certain number of days. Even the court rulings which address repeated, some say more than once. In fact, 2 that were cited by the government.
So if one juror thinks that repeated is 2 or 3 times and another thinks it's 3 or 4 times, whether they all agree that it's 3 or 4, so long as it's more than once, and the occasion is that he didn't just come upon victim at just one time, wouldn't that satisfy the elements of the offense or for the repeated part of the definition?
I don't mean to sound facetious, but I mean, it depends on what this panel thinks. I think that the statute needs to be sufficiently clear to provide the fair notice and to prevent arbitrary enforcement by law enforcement. So will law enforcement generally be able to apply the advanced stalking statute to apply these undefined terms, malicious, repeated, and in violation of court order? I think they're legal issues rather than jury issues, other than on the sufficiency for maliciously.
It seems it's just sort of common sense. If you do it more than once, you've repeated your actions. And that's pretty obvious, I think, to almost anyone. The violation of court order, I mean, it seems that your argument is that there has to be a determination that the court order is violated, but wouldn't that undercut the
intent of the statute to provide protection for victims of domestic violence? Or, you know, you have to wait until a court makes a determination that the order's been violated before you can go forward under the advanced stalking statute. Is that your argument on the violation of the court order?
My argument is that the statute is not sufficiently clear to provide the fair notice and prevent arbitrary enforcement on on the violation of court order. I realize that there are varying degrees of strength on these three element arguments, with repeated probably being the most difficult to persuade. Nevertheless, I think that it merits review by this court for prospective guidance on how this statute should be interpreted. But I don't know. There were three violation reports were filed. There was never a violation hearing. There was never a revocation request and no adjudication. So yes, there was a court order in place at the time that the alleged contacts occurred. So, you know, maybe that's sufficient.
Mr. Paris, there's a misdemeanor crime violation of court order.
I'm sorry, Your Honor.
There's a misdemeanor crime violation of court order.
Right.
Do you know if that has ever been construed in terms of whether the court has to somehow find a violation, or does the jury simply consider whether the defendant violated the order of the court?
I don't know, Your Honor. I don't know if there's been a prior adjudication of that. I just don't know.
Does the fact that there is that misdemeanor crime and this is a felony require a greater sense of the requirements to meet the felony statute? Because I don't believe the violation of court order has these requirements of maliciously or repeated, obviously not repeatedly, but.
Right. Well, I mean, what I'm only talking about this as an element of the advanced stalking statute and whether or not it passes constitutional muster in terms of vagueness. So it's not clear to me whether or not it appeared to me to be an issue that if one of the elements is in violation of a court order, whether you need to have an underlying violation adjudicated. I didn't find any prior rulings from this court which required that or did not require that. And that's why I present it in this appeal. I'm not saying I'm right, but it does, you know, it's not a clear issue, I think, and I think it merits review by this court for guidance as to how to apply this statute. I do think that out of fairness, that because of the vagueness, that my client should, that his conviction should be vacated because these elements are vague, particularly as to maliciously. And I understand the argument, well, if there's a court order and you choose not to follow it, are you being malicious? And there is a definition in the dictionary which says that violating a person's rights could be maliciously.
If we were to agree with you that this is constitutionally vague, could we order that the court convict him of a lesser included offense, violation of a court order?
I don't think so. I think that would have to be a jury determination. I think this court's call would be to, it's not for me to tell the court what it can and can't do, but I think that would be a jury issue. I think it would be, but I think if this court finds that it was unconstitutionally vague, or that it was insufficient evidence, that it would result in an acquittal. And if I'm right about that, then it would be prohibited from being retried under double jeopardy. I think that's how it would play out. But I don't know if I answered Your Honor's question about the maliciously. I mean, I realize that that's appears to be an issue this panel might be.
So if I understand it, then you're moving away from your argument that the only way of violating the malicious part of the statute is through ill motive and having some evil intent, because you did point out that even recklessly disregarding the law would seem to satisfy that he acted maliciously.
No, I'm not abandoning the argument, Your Honor. I'm just saying that there are different definitions, and our statute has not said which definition applies. And because the standard is whether or not there's fair notice and whether or not we can avoid the danger of unfair or arbitrary enforcement, there needs to be some guidance. So is it so broad?
But how does the lack of definition, I mean, you listed questions that the lack of definitions may lead to arbitrary enforcement, and you proceeded to enumerate certain parties, individuals that are at play, the judge, the lawyer, in that they can act arbitrarily. But you never really gave an example of how this arbitrary enforcement would apply because there are a lack of definitions. I didn't glean that from your brief.
It happened here. It happened here. My client went and interacted with his former spouse. He asked her to drop the case. He hadn't seen his kids. He wanted to see them. And, he was told he can't be there. He left and he apologized. Does that constitute maliciously? I would say it does not.
But how is that an arbitrary enforcement on the part of law enforcement?
Because they arrested him and he's been charged and he's been convicted.
Because it's their understanding that, and maybe for good reason, that when someone there is a domestic dispute, there's a stay away order that the victim not come around, and then the defendant does, and she proceeds to call police officers, and they come and arrest him for violating the court order. How is that an arbitrary enforcement of the statute?
It wouldn't be arbitrary if it were focused on the violation of court order. Here we give the police too much discretion to figure out whether or not there's a violation or not, because we have no definition. One police officer.
So it's your argument then that there must be a finding that he violated the court order before he can be arrested?
I was focusing more on the issue of maliciously.
I understand, and that's of course a big part of what we're struggling with. But as you pointed out in the outset, it's a two-part test: fair notice and arbitrary enforcement of the statute by law enforcement. And I'm trying to I'm asking you to come up with an example of how the lack of definitions, the lack of definitions would make it such that the violation of I've lost my train of thought, but it's the lack, how the lack of definitions would meet the second part of that two-part test of arbitrary enforcement by law enforcement officers.
If he had come and told her, "I love you," he shouldn't have done that, arguably, because there was a court order saying no contact. Would an officer consider that malicious because he appeared in violation of a court order, arguably? Or if he said, I mean, the cases that the government relies upon, I mean, we're talking about protracted conduct of violence and threats. I'm going to kill you, you expletive, and actually harming somebody or threatening to harm them.
But wasn't there evidence of
abuse already in this case, and that's why she got the stay away order. And so if he's coming in violation of that order, isn't that without legal justification, which, you know, at least could be defined as a malicious act, at least, you know, within the dictionary definition of what is a malicious act? It's one without a legal justification or excuse.
Maybe. First, that prior evidence was admitted for a limited purpose to establish how the order came about. And the reliance upon that to then apply to the elements of this case, I think would not be fair. But putting that aside, in answer to the question, if there's an order and you violate it, you're arguably violating somebody's legal right. And does that come within the prohibition of the malice element? And the answer is maybe, maybe not. What was the intent of the legislature when it
Well, I mean, I think one could look at the definition, for example, of maliciously versus if you accidentally ran into her because you both show up at the shopping center at the same time. I mean, that's not I think a scenario that the stalking statute was intended to cover. But when you have a scenario where, you know, he goes back 4 times to the home, 3 times in a 2-day period, and he's got this court order, and in the court order, he also signs something that acknowledges that if he violates the court order, he could be subject to other criminal prosecution. You know, I mean, I'm not necessarily convinced that because he goes to her and he says, "I love you," or "I want to see my kids," that he's not violating the court order without legal justification. You know, the fact that he's trying to get her to drop the charges, or he's not going there in a threatening manner, I don't think we have to wait until something happens or he threatens her when you have the stay away order. I mean, that's the purpose of the stay away order, is to prevent it from boiling up into a situation that later you regret occurring.
I agree. And there are remedies for violating the court order. Justice Merriman brought up one, which is prosecute him for that. The other is hold him in contempt of court, revoke his release conditions. If he committed an offense while under release, charge him with that enhancement. But the problem really that I see is with no definition of malicious and having these different possibilities. How is an ordinary person to know whether they're committing prohibited acts, and how is law enforcement to know how to enforce it? And I think the danger is you're going to get multiple opinions from multiple law enforcement officers, and same with ordinary people, whether they know or not know if they're committing criminal conduct. And that's what I see as the problem here. I think there are so many different ways. What was the intent of this statute? And with no statutory definition, no jury instruction regarding what it means, no prior case holding, court finding of vagueness, how is a jury supposed to make a determination? You probably are going to have 12 jurors thinking, you'll have different opinions as to what it means even within their deliberations, and that leads to the problem of whether or not you have a unanimous verdict. Anyway, if there are no other questions, I'll reserve the rest of my time.
You have 30 seconds remaining. I'll give you 2 minutes on the vote.
Okay, thank
I'll
you.
give you 2
Minutes of rebuttal, Mr. Pierce.
minutes.
Chief Justice, may it please the court. The statute involved here really, it addresses a societal issue that's been at the top of society's mind since the 90s, when Congress adopted the Violence Against Women Act, which Guam acknowledges the importance of. This statute is really looking at preventing potential violence against women and other domestic relationships. The people rely on their written argument in their brief. I would really like to focus on 2 issues I think will be of help to the court in making a determination in this issue. The first is going to be looking at the structure of the statute, and the second is going to be looking at how we can make that statute vague in the same way the statute in Shimizu is vague. Really, there's been 3 issues raised, maliciously, repeatedly, and in violation of a court order. In regards to the violation of the court order, the statute doesn't state that. Actually, 19.70 subsection B provides a person is guilty of advanced stalking if he or she violates subsection A of this section when there's a temporary restraining order or an injunction or both, or any other court order in effect prohibiting the behavior described in that subsection against the same party. There's no statement about violation of a protective order. It's violation of subsection A. And I think we can summarily dismiss with the argument that since there's no finding of a violation of the protective order itself, rather we're looking at, was there a violation of subsection A? And that's really where the substance of this appeal is. Now, subsection A is comprised of 2 prongs. A person is guilty of simple stalking if he or she willfully, maliciously, and repeatedly follows or harasses another person, or who makes a credible threat with intent to place that person or member of his or her immediate family in fear of death or bodily injury. So those are 2 separate prongs. We can find harassment, or we can find credible threat, or you could find both, but you only need to find one of those. Now, when I read 19.70A, and I think it's notable that there was discussion in the trial court that there'd be jury questions about what does malicious mean? What does repeatedly mean? What does willfully mean? The jury had the same question I had when I read the statute, which is, if we find guilt, do we have to find that all 3 of those elements were met, willfully, maliciously, and repeatedly? That was the question I had. And being a lawyer, I was able to read it and discern it's all 3. It uses the word and instead of or. That's the analysis the trial court did and the counsels in trial court did. Now, the crux of the issue is really, in this case, I believe, maliciously. Now, in digging into these words, I did 2 things. One, I went to Merriam-Webster's. I prefer Black's Law Dictionary, but we're talking about the common person here. Merriam's is better for that. I also did an unofficial survey and talked to a few laypersons regarding what they thought malicious or maliciously and repeatedly meant. Now, if I can find in my notes. On the first page. No, I'll do it from memory. I can't. Oh, here we go. So repeatedly. Now, if we look at repeatedly in Merriam-Webster's, has one definition, it's again and again. Now, I asked some laypersons, how do you interpret repeatedly? And my response to that question is it's more than once, which seems to be Justice Carbolito's definition, I believe. My surprise was almost every layperson I asked said it's more than 2 times, so at least 3. And that's in line with some other jurisdictions that have held that repeated a series of events is at least 3 events. In that case, we've met that. Mr. Manglona went to the property 4 times while the protective order was in place. There's questions as to, well, what's the duration of repeatedly? Is it 1 year, 5 years? When do you break that chain of repeated? And in this case, I'd say that, and the jury would have considered this, that the protective order was in place during this entire period of time. And as a result, all of those visits during that protective order constituted repeated visits in violation of the protective order. Now, maliciously is a little more, people I've asked had a harder time with that word because it's a hard word to define. However, despite it being hard to pin down, it has similar meanings. All of its meanings do not deviate. They have the same general purpose. Now, if we look at Merriam-Webster's, it really had 2 definitions, one of which discussed ill will, bad intent, intent to harm someone. However, there was a second definition which stated that, and this is for malice, intent to commit an unlawful act or cause harm without legal justification or excuse. Now, in my unofficial survey, the layperson said they had some trouble with malice, but they said it's when you do something bad, you do something wrong to harm someone, to cause grief or to cause pain or injury. In a legal sense, I'd say it's an act in bad faith. It's something done without legal justification. It's an improper action taken to impinge on someone's rights and in prohibition of the law. So
by that, do you conclude then that you listed 2 ways, as I understand your argument.
Mm-hmm.
Number 1 is with ill will, ill motive, and the other is, as you said, violating someone's rights. And in this case, the victim had the right not to be bothered by the defendant because there was a stay away order. And so by him ignoring, disregarding that court order, then your argument is that he acted maliciously by disregarding the law, disregarding the court order, which is what applies in reference to the facts of this case.
correct. And I would refine that further to say that a jury could find that those actions were malicious. There were jury instructions regarding just even reasonable doubt, and the jury using common law to draw inferences from evidence and to make determinations. I think at the heart of this statute in this matter really is the nature of conduct being restricted, which largely pertains to domestic violence situations. It can be very, I don't want to say the word broad, but it can constitute many different acts that in some cases could appear to be innocent but may not be. For example, there's been discussion about Mr. Manglona missed his children. That's an understandable emotion, to miss your children. You're separated, you can't see them. However, when we look at domestic violence situations and even family disputes, children can be used as a source of leverage, as a fulcrum. In this case, Mr. Manglona didn't just go to the property to see his children. He also would then talk to Minami and try to get her to drop the protective order, try to get into the house. And the protective order provided that, one, he was on house arrest. He wasn't to leave a location. The record reflects that someone called his auntie and his cousin or someone had to come pick him up and escort him back to the house he was staying at. Secondly, the protective order prohibited harassment. And that's another key component here is this is all prohibition against harassment. And harassment is defined in the statute. Harassment is a knowing or willful course of action which serves no legitimate purpose, directed at a person which alarms, annoys, or distresses that person. Now further, the conduct must be of a nature to cause a reasonable person to suffer substantial emotional distress, and in the person being harassed, it must in fact cause that. So if we were to look at this statute through the lens of Shumizu, which perhaps is more of a terrorizing than a threat to impose violence, would harassment have been met here? Possibly not. Largely because there was evidence in the record that the daughter had an anxiety condition. She was on medication for it. Would a reasonable person have feared imminent bodily harm because the mother said, "I'm going to kill you," and then went outside and rummaged through her purse? Probably not. However, in this scenario, a reasonable person who has a protective order in place against their spouse, when there's an established prior history of domestic violence, a reasonable person would have some concern about harm. They would have substantial distress of someone coming to their home 4 times in violation of a protective order that says you can't be here. Now, in line with discussing Shimizu, this statute can be made vague in the same way that statute was vague. And the way we do that, I think, is we remove the words willfully, maliciously, and repeatedly. Now, if we do that, the statute is going to provide that a person is guilty of simple stalking if he or she follows or harasses another person. Well, when does that apply? Does that apply, as Chief Justice Torres said, when someone goes to the grocery store and accidentally runs into someone? Under that construction, yes, it could. There's some confusion as to when that applies. However, if we're looking at the circumstance of an accidental run-in at the grocery store, we have willful, we have malicious, and to a lesser extent repeated. That's not so important for this example. But it's not, going to the grocery store is willful, but the willful intent isn't to go see the person. And there's no malicious act in going to the grocery store and you accidentally run into the person with the protective order. Now, upon realizing that under the protective order, you have an obligation to then leave the premises, come back later, go to a different grocery store. Now, if you were to go to the grocery store with the intent of, oh, this person is always there, there's a chance I might run into them because I want to talk to them about the kids or dropping the protective order. That's a very different situation. That's something that this statute might protect against. Under the modified statute, other examples can be violations. What if, without those willful, malicious, repeated requirements, a son calls his mother every other day, she has diabetes, it annoys her, and she says, "Why are you wasting your time? Stop calling me." Would that be harassment? If for some reason she called the police and said, "Hey, my son's harassing me, he calls me every other day to check in on my welfare and he's annoying me, I want to press charges." Under that statute, yes, that could be determined to be harassment. Now, would that be within the realm of what the intent of the statute? No, it's beyond the realm of the statute. So despite the fact that maliciously and repeatedly aren't defined, those words really are intended to limit the scope of the application of this statute. And the case we have before us, this is exactly the kind of conduct the statute was intended to prevent. This is a situation with a protective order, and the protective order isn't necessary. It's just an extension of the sentence, an enhancement. But the real intent of the statute is to limit and prevent this kind of behavior where there's a potential for violence.
Isn't there another statute under Guam law that does exactly that?
Could you direct me to the statute you're considering?
Violating a court order as a misdemeanor.
Oh.
All you have to show there is the defendant violated the order. So my concern is, how is law enforcement going to know whether, as it's been suggested, showing up to ask about the kids isn't really malicious behavior, and he could just charge violating a court order? Or does the second degree felony, which is a much more serious offense, mean that the defendant has to clearly be on notice of other behavior besides just violating the court order? And how does a law enforcement officer distinguish in a case like this? Clearly, if he shows up with a gun ready to shoot her, that's other charges, but that didn't really happen here.
Yes. So a few elements of this question. Regarding the gun, fortunately, that did not happen here. There were no threats of credible harm at the visitations. However, I think the harassment prong covers the visitations that did occur. Regarding the contempt, the violation of the order, the protective order, as to if it's a misdemeanor or not, I'm not sure. We could provide supplemental briefing for the court on that, if that would be of value. My gut feeling on that is the violation of the court order it's a matter of contempt. It's a violation of the court's authority and power, and
It's a misdemeanor crime.
it's a misdemeanor. Okay, thank you. So in that sense, and I believe there was an arrest for the violation of the protective order. Minami called the police on one instance. And I know at one point she called the probation officer and put her on speaker, and she told Mr. Manglona, "You can't be here." In regards to the violation of a court order, I think the court order is set forth specifically enough to say, one, you have to stay at the residence you're designated for. Two, you can't come to the Minami's property and harass or the residents of that property. And three, I think just merely by the police arriving and him being there, having evidence that he was there, that's sufficient to provide for an arrest. Now, could that charge have been followed up with a misdemeanor? Yes, it could have. I think, however, that upon the arrest and looking through all the evidence, it was found that there was a basis for a stronger charge of violation of the stalking statute due to the violation of Minami's rights. And I think the public interest in protecting women from potential violence. While none of that was shown in the immediate record of his visits, there was some in the prior record of some physical violence. And as to the malice issue, I really do believe.
Before you move on there.
Yes.
Because you stated that by the defendant violating the court order, that he acted in disregard of the law. Mr. Perez was, as I understand, part of his argument is that because there were two ways in which that you have set out that the malicious definition could be violated, that's ill motive, ill intent, and as opposed to just disregarding the law, which is in this case the court order. And the argument and the evidence is that he was just there to visit his children, and that there was no ill motive, evil intent. And so since there was no definition of what maliciously meant, and there's a possibility of two different interpretations or two different definitions, how does the jury come about in forming a unanimous verdict? Which part of the statute is meant here in this particular case?
I think part of that can be addressed through the jury deliberation, but I think the other aspect of it is when the legislature passed the statute, I think in a way strict definitions of a word like malice, which, as I stated earlier, malice is, well, it has a couple definitions. They don't deviate from each other. They have the same core thrust as to a bad faith intent, whether that be against the law or to harm someone or something else. Now, if we were to limit the definition of malice to one or the other, I believe there's situations you'd have where conduct that should be subject to this statute would no longer be subject.
I don't think the argument is limiting the definition to one or the other. It's when no instruction was given defining malicious, how does the jury determine which part of the definition of the statute applies in this particular case, so that the jury can then arrive at a unanimous verdict?
I understand. Slight change on what I was arguing or discussing. So we don't like the word, but I think it's subjective and it depends on the context of the acts that occurred in the record. So the jury has to take, we're not looking at this in a vacuum. There's facts that occurred, there's situations that occurred, and the jury has, under a reasonable doubt, a duty to apply common sense, to look at these situations, to look at the common usage of words. Words can mean lots of things. Malicious means several different things, but the jury can still look at those facts in scenarios and consider and deliberate and discuss and determine, well, which aspect of malice is this? Is this the malice of ignoring the law? Is this the malice of taking a harmful act against someone? Because even if we talk of, he wanted to see the children, which is a noble goal. It's noble for a parent to want to see their children, to miss their children. That's an understandable human trait and emotion. But when we're looking at these kinds of situations as well, there is also the use of the children as a means, as a leverage, as a fulcrum to, drop the protective order, drop the case. Let's try again. Let's, as opposed to going through the regular channels of family law court or the other judicial processes which are in place to channel these kinds of disputes. And I think that's where the malice comes in here, is it was an improper conduct in violation of that order, in violation of judicial standards and other procedures and remedies available to try to circumvent those things. It is not uncommon to have a domestic dispute issue, and regularly here, they ignore, they go, they talk amongst each other, they get revoked, then they're back in place, they get revoked, they're back in place. And Mr. Manglona also acknowledged after he was arrested, he apologized for visiting the house. He acknowledged that that was a wrongful act. It was something that he shouldn't have done. It was contrary to the law. And in that sense, that is a part of malice. It's a violation of the law and of rights of others, whether it be ill intent. Is the ill intent the mens rea, or is the malice the impact on the person? I think the malice does impact the mens rea a little bit, but I think it also ties into what was the motive of it. Had it solely just been, I want to see the kids come out, there's visitation with the kids, that's one thing, but to segue into the protective order, into dropping the case, into an hour-long discussion, I think that's where we go beyond kind of that good faith wanting to see the kids and more into trying to use some leverage inappropriately. Now, in regards to Shamizu, and I'll wrap up, the real concern there was overbroadness, vagueness, and arbitrary and capricious enforcement against having too broad of a net, catching people that possibly weren't offenders, and lack of fair notice to people, not knowing what proper conduct is. For example, I don't remember the name of the case, but no loitering with no apparent purpose. Well, what's apparent purpose? In the Shizumu statute, the reckless requirement in regards to creating a fear of harm in others. Well, that has no subjective test as to was the person's fear reasonable? Was there imminent harm? Are we maybe going a bit beyond the scope of the intent of the statute? And we don't really see that here. There is a little bit to grapple with malicious, but it can be done. The jury didn't have any questions as to what malicious meant or repeatedly meant. They had a question as to, do we need to find all three of them? The answer was yes. And the jury, based on the evidence, did find all three of them. They found that the actions were taken while a protective order was in place. And they found a conviction of Mr. Manglona for stalking, or for advanced stalking. Yes, advanced stalking. And on that basis, the people would request that this court uphold the trial court, on the conviction in the trial court, and hold that the word maliciously, repeatedly, they're not overly vague, they're not unconstitutionally vague. They have commonly accepted meanings, and a jury is capable and intelligent enough to look at those words and apply them to facts and scenarios and to properly tailor a conviction when necessary.
But you agree that if you were prosecuting this case or a similar case after this completion of this case, that you would probably think that it's a good idea to provide definitions of these three words, don't you think?
Yeah, going forward based on this scenario and whatever decision the Supreme Court should enter, regardless of the jury not asking, those questions, in hindsight, I think there was some wisdom in providing guidelines on what those words mean and not just relying on, we trust the common sense of our juries, but guidance is always best.
Thank you, Mr. Dennison.
Thank you.
Mr. Perez, we give you 2 minutes, we said.
Thank you, Your Honor. So I just want to start by saying that disregard of a court order is a separate element, and it's an element that changes it from simple stalking to advanced stalking. So we still have the underlying element of malice, which is contained in both simple and advanced stalking. And that must be proved as to maliciously harass. What is malice? Is there fair notice?
The advanced stalking, if you look at the statute as was pointed out by Mr. Tennyson, you're guilty of advanced stalking if you violate subsection A when there's a temporary restraining order.
Right.
So it doesn't talk about the violation of the order itself.
True.
True. Right.
Right.
So the violation of the order is not critical for advanced stalking. It's the fact that the order is in existence and you do the acts that are complained or set forth in subsection A.
Right. I agree.
Okay.
So what is malice? We know that the AG couldn't define it definitively in their brief. They gave alternative definitions. The court could not give an instruction and found that the term was vague. There was no statutory definition. There's no prior court holding which gives us guidance, and multiple dictionaries will give us multiple definitions, which shows that there is no consensus as to what malicious means. If the AG and the court in a dictionary can't define it definitively, and if the statute is silent, and if there's no prior court case guidance, how could a jury apply the statute? How could law enforcement enforce it? And how could an ordinary person know whether they are in violation of it? We have the principles of ambiguity. The legal principle of ambiguity in contract, you construe it against the non-drafter. We also have the rule of lenity, where if there's ambiguity or if there's a way of interpreting a statute or a provision in favor of the defense, you do that. And in this case, with the ambiguity, it should be construed in the defendant's favor.
All right. Thank you, Mr. Paris. Thank you, Mr. Tennyson. The court will take the matter under advisement. We will issue a written opinion and we'll